Thanks for joining this episode of the number 86 lecture series, in which Professor Richard Epstein discusses the Roman law of contracts. Episode 1 explores why we need contracts, how contracts worked in the Roman system, types of contracts, and why these categories are important. This lecture is part of a series with Professor Epstein on how this ancient legal system can provide crucial insights about modern problems. Professor Epstein is one of the most prominent legal scholars of our day. He is the inaugural Laurence A. Tisch Professor of Law at NYU School of Law, a senior fellow at the Hoover Institution, and Professor of Law Emeritus and a senior lecturer at the University of Chicago. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Why do we need contracts?
When you acquire property and you start talking about either its outright transfer or the creation of divided interest, there is only one mechanism of which we are aware to do this, and that's by a voluntary agreement between two parties. So essentially what happens is the basic theory of contract, which applies everywhere, is that you have two major kinds of assets. You have labor on the one hand, and you have external property on the other. And what you realize is that there can be advantages to trade in labor and in property. Now, the law of contract talks about all these things. What it then has to do is to figure out exactly what the mechanisms are going to be and what the rules are going to be to make sure that these voluntary exchanges take place. And the stress on the word voluntary is extremely important because the theory of a voluntary transaction is I surrender something to you that is worth less to me than it is to you, and you sometimes surrender something to me which is of greater value to me. That's called an exchange. But there are also other transactions in which it turns out that for good and sufficient reasons, I'm prepared to give you something and not to ask for something in exchange. Sometimes I do this because you're the object of my natural love and affection, and I get satisfaction, some kind of utility out of the fact that you are made happy about what's going on. But in other cases, these things are essentially inducements for further transactions. So to give you a very homely example, you go into the bakery and you're trying to figure out whether or not to buy a dozen cookies. And sure enough, there'll be a tray out there and you could take a sample of a half a cookie to see whether or not you like it. You're not going to be charged for this thing if you eat it. And the reason you do it is you think there's a 70% chance that they'll buy the package and I'm better off giving them these things. There are other kinds of options that you give to people. I'm going to keep this contract open for an hour or two so you could decide whether or not you want to buy it. And you may require payment for it or you may not. But generally speaking, what happens is that people have all sorts of business and personal motives for doing these things. So the question about the law of contract is, if you start to see a series of voluntary promises, whether reciprocal or not, between two particular persons, you assume that there's going to be this gains from trade. And that's why all forms of contract are going to be linked together.
What sort of transactions might be involuntary?
Then the question is, what are the enemies of voluntary contract? And at this particular point, one goes back a long way to Aristotle, and you start to figure out what the things are that can undermine contractual security. And the most powerful of these things turns out to be duress, which is the threat or use of force by one person against another. And what we mean by that is somebody says, I would like to buy your house and to pay you $100 for a $500 house. And oh, by the way, if you don't agree to the deal, I'll blow your brains out. Under those circumstances, you're supposed to agree to the deal. But on the other hand, when the gun is removed and you have the time, what you can say is, look, the duress essentially meant that there's no reason whatsoever to believe that this transaction was for mutual benefit. So we're going to have to set it aside. And then what you do is you figure out exactly how and when you do it. And one technique would be to say, when the time comes for me to convey the house, and he sues to get it, I would say, I don't have to do it because I've been duressed. On the other hand, if the transfer is already complete, then it may be a slightly higher burden of proof. But now, in effect, you can sue in order to recover the property on the grounds that it's unjust enrichment for somebody to have obtained something by property if the use of force has been involved. Whatever you say about force can be said about fraud. If you lie in order to get a deal, what you're basically doing is telling somebody that the thing has a value to him greater than he suspects or a cost lower. And if he knew the truth, he would not do this thing, because now what was a positive transaction for him becomes a negative transaction. Once you start doing this with fraud, you're going to have to worry about non-disclosure. You're going to have to worry about concealment. Then you're going to have to worry about misrepresentations that are not fraudulent, some of which may be negligent, some of which may be innocent. And in all of these cases, you have to figure out whether or not these particular impediments to contract are going to allow you to upset the arrangement. And finally, there's the general problem of mistake, which we've already encountered in connection with those various issues on accession, where I happen to make my particular statute out of your piece of bronze or your piece of stone. And so it may well be that there's an innocent mistake, and I believe that certain facts are true, and it turns out they're not true, and if I knew the truth, I would never make the deal. The question is, can I set aside a transaction when there's a mistake? Does it matter whether it's a mistake made by one party only or whether it's a mutual mistake and so forth? So these kinds of vitiating conditions are something that run through the entire body of contract law and are not necessarily tied up to this, that, or the other form of contract. So that's the kind of general part, the logic of gains from trade and the examination of those kinds of conditions, which essentially in the formation of the contract make it unlikely that the transaction that emerges is one that would have met the consent and the willingness of the party who is actually now trying to undo this thing in one way or another. So these contracts, of course, are very much different from the situation of coercion, because in coercion, it's pretty easy to say, if I want to beat you over the head and do so, it's generally going to be a case that it's for the loss. If I want to take your property, it's going to be that way as well. And so whenever there's the use of force, you then have a heavy duty to sort of justify the force in question by self-defense and necessity or by consent or something of the sort. And the key problem, which we'll talk about at the end, is to the extent that force is used as part of a consensual arrangement, whether it be by way of theft or whether it be by way of harm, you're not quite sure whether you're on the contract side of the line dealing with mutual gains and positive sum transactions, or on the negative side where you're dealing with transactions which, if allowed to replicate, would essentially create social chaos, the sort of issue that we talked about when we discussed natural law.
Is a contract always a complex arrangement?
Now, the next question that you have to face in the law of contract is the question of classification. It turns out that what happens is, as a matter of course, is that people, when they enter into contract, usually think about some fraction of the relevant issues, but they don't necessarily think about all the particular details in question. And a lot of what the law of contract does is to try to set up a series of terms which you may be free to vary, but typically won't even think about when you're worried about a particular transaction. So let me just give an extremely simple example. Is what happens is I go into the store and I say, I'd like to get a pound of potatoes. Now the question then is, what's the sequence of performance in this particular contract? We haven't said a word about that. And so can the following thing take place, in which the proprietor of the business doesn't give you the potatoes, but he says, you promised to pay me $2, so I'm going to sue you now for the $2, and you could turn around and sue me for the potatoes later. And everybody kind of looks at this and says, well, that clearly has to be very wacky to do these things. And so if you were to tell people, this is simply a case where you have to tender in order to sue, they say, I don't know what the word tender means, because we're not talking here about tenderness in love and in personal relationship. What we mean by tender is whether or not you've done everything necessary in order to complete the transfer of the goods, except handing the thing over, or the same thing with respect to money. And so what we do is we imply a series of concurrent conditions in these transactions. And what the conditions say is, I do not have to pay you for the potatoes until you tender them to me. And you don't have to tender the potatoes until the cash is ready on the table. And the theory is each party can treat its promise as security for the others so that they go forward simultaneously or not at all. And this then becomes part of the implied law of conditions. And there's a kind of deep rationale, as applicable in Roman times as today, as to how these conditions are inferred, What you're trying to do is, when an agreement is as skimpy as the one that I've just mentioned, is to impose terms on the conditions for payment and delivery that minimize the credit risk for both sides. And that's surely going to be much more efficiently done if neither party has to provide performance until the other side has tendered. And once you do that, that arrangement has been formalized in Anglo-American law, and it was also part of Roman law.
Can you elaborate on how contracts worked under Roman law?
And at this particular point, the phrase that often comes into use is it's good faith. And what we're saying about good faith is these are the kinds of things that you have to do in various kinds of arrangements in order to make them robust. So that if you, in effect, act in bad faith, then it turns out that I don't have to do this at all. And so what the Roman law does is it develops bona fide contracts, and those are typically sale. They're contracts of hire, contracts of partnership, and contracts of agency, which we'll talk about. And then there are other promises, like loans and so forth, which tend to be strictly iuris. And then there are a third class of contracts known as real contracts, in which it turns out that what you do is you have various kinds of gratuitous arrangements, and you have to sort these things out. So what the Romans do is they develop a very elaborate system. And the genius of what they've done is they seem to get the right categories for the various kinds of arrangements. And they seem, as a first approximation, to get the right substantive rules as default terms for each of these kinds of arrangements. And for the most part, what they do is they allow, but only occasionally, you to vary these standard terms to do something else. Now, why is it there tends to be relatively low variation from the standard background terms? And a lot of it has to do with the fact that parchment is expensive, that agreements are hard to do. And if it turns out that you have a very reliable set of default terms, everybody can rely on those without having to draft these large agreements and so on. Even today, default terms dominate ordinary casual transactions. Every time you go to the supermarket and you enter into a transaction and so forth, you do not go up to the teller or to the cashier and say, you know what, I'm buying these potatoes, but if it turns out that when I open one of them up and it's rotten, then I'm going to bring it back to you. Or what happens is when the potato was rotten, you say, you delivered rotten potato. And they say, oh, I'm sorry about that. Take it. Here's another potato. Here's your money back. And what that turns out to be is the warrant of merchantable quality. We don't call it that, but the moment somebody describes to us what the situation, it turns out that we know exactly what's going on. And so this process of implication into contract is the central challenge about the way in which this thing works. And at this point, instead of having a general theory of vitiation of contracts because of force, mistake, non-disclosure, and so forth, we have a much more articulated system which starts to deal with the implied terms of particular contract.
How many basic types of contracts are there?
Now, as I mentioned, there are three classes of contract that we care about. These are the real contracts, the formal contracts, and the consensual contract. There's a fourth class called literal contracts. Nobody actually knows what they mean or how they work, so we're just going to ignore them and start with the real contract. So what is a real contract, and how does it start to take place? Well, essentially, these are contracts which, under their formal articulation, are said that they're not enforceable when they're fully executory. They're only enforceable when a piece of property, a race, a real thing, has been handed over from one person to another. So the first thing you have to understand is, what does this word not fully enforceable in an executory fashion mean? And essentially, in a world of fully enforceable executory promise, if I promise to you and you promise to me, each of us is entitled to sue, even if they have yet to perform. There may be obligations to tender, but they don't have to wait until they've done something in order to sue. And that means, in effect, in contracts of sale, these things are highly stable because of your ability to recover lost profits before you actually turn over something to somebody else who is simply not going to be able to pay for it. If you don't deliver the goods, you can't act as though you have delivered them and get the full price. And so we have different measure of damages, which is part of the difficulty associated with these contracts and why it is that the law, to fully exposit them, it can take a very large and complicated volume when you go through all these variations. Now, the real contracts are not, for the most part, commercial contracts. They are gratuitous contracts. And so the first of these contracts is called mutuum. M-U-T-U-U-M. And what this sort of means is from me to you. And what's the situation? Well, the first question you always ask is, have you ever entered into a contract for mutum in your life? And if I were to look at the typical view, they say, I don't even know what the world you're talking about. I certainly haven't done anything so foolish as to enter into a contract that I've never understood. But of course, you've entered into contracts of mutum for 1,000 times. You just don't call them that. You understand what the rules are because you're essentially a slave to the natural law principles that we started to talk about from the beginning. So what's a contract of mutum and what are its incidents? Well, suppose it is you're late at night and the stores are closed and you need to have a stick of butter in order to make your dinner. So you go to your next door neighbor and you say, could you lend me a stick of butter? And the neighbor says, sure, and gives you the stick of butter. Now, it's odd to call this thing a loan. Why is that? Because you're not going to return this particular stick of butter. What you're going to do is you're going to use it in the frying pan and make your particular dinner. And tomorrow when you go to the store, what you're going to do is buy the same brand of butter in the same quantity and give it back to them. And so what happens is this contract becomes enforceable, not at a promissory level, but only when the stick of butter is delivered. That's what a real contract is. And so why would we want to have that arrangement? Well, suppose we did it the other way around, and somebody says, this evening I'll give you a stick of butter. And then the evening comes and they don't want to do. Do you really want to have a lawsuit to sue for the tiny amount of money that's involved in this case? And the answer is nobody thinks that way. Just ordinary expectations are, if they decide that they're not going to perform, you may be a little bit miffed at them, but you'll get a stick of butter from somewhere else. But once you've given the stick of butter, now there's a much larger stake on the table. And so you have to basically return a stick of butter of like quality and kind. Why is it that you have to do that? Because otherwise what happens is transfer results in unjust enrichment. You get a very nice stick of butter of high quality and you return an inferior brand. It's as though you received $10 on the one side and you're returning $8 for a $2 gain. So the transaction is that. Then there's the question about what it is that you do if it turns out that after the thing is delivered, somehow or other it all doesn't make it into the pan. Somebody drops it or breaks it. And here the Roman maxim was perfectly clear. It was a maxim which was known as res perit domino, which means that the thing perishes domino for the owner. What happens is you have not borrowed the thing to return this thing. You've borrowed it as a loan for consumption. So if it turns out that the thing is not consumed, the risk falls on you because you're in control and in possession of the thing. And it would be very odd to say, most people would agree, if when I get the stick of butter and I drop it by mistake into a dirty place in the house and I can't use it, that I can say to the other fellow, well, I screwed up in the way in which I managed this property, so therefore I don't have to return it to you. The usual correct rule is we want to put incentives on the party in possession of a thing to keep it safe. And the best way we do that is to say, okay, the risk is on you. You still have to return the dusters. Now, the next question you have to ask is, well, what about interest on this thing? Well, conceivably, you could borrow a stick of butter and wait 6 years before you return a like stick of butter. And then if the stick of butter was worth $10, you can have the interest on $10. But mutum contracts don't work like that. You borrow the stick today, and it turns out that you return it tomorrow or the next day. Thinking about interest kind of arrangements is quite bizarre, given it's such a trivial stuff. And the other thing to note is that these mutum contracts are extraordinarily common. So I borrow a stick of butter from you today, and you borrow a pound of sugar from me tomorrow. If, in fact, these things have a kind of reciprocity, the whole interest term starts to clear out. And so what we say, in effect, is that there's no interest on these arrangements.
What about contracts that deal with much larger transactions? Do the same rules apply?
And then somebody says, well, suppose this becomes a really big sort of transaction. We're not just talking about a pound of sugar, we're talking about a bushel of sugar. Well, at this particular point, then the stakes are going to start to be higher. What you do is you start to switch this thing around. Generally speaking, you could have it as a contract of barter. But oftentimes what you'll do is you'll say, since we want this thing to be financial, what we'll do is we'll make it into a contract of sale. And the moment there's a contract of sale, then it turns out you're paying money rather than returning the like kind thing, which is in the ordinary commercial areas what you want to do. Generally speaking, if you buy something for resale, you don't want to return it to the original guy. The gain comes from its use or its resale. And so now you switch the form, and now the contract of sale will start to take over. And since that's a real business transaction, the executory enforcement starts to make a lot more sense. Now, the last point to understand about this contract about mutum is that there is not necessarily consideration for the enforcement. The original situation is a favor to one person, so the contract is thought to be gratuitous. And since it's a favor, generally saying you can't enforce a gratuitous promise, in fact, and make the guy deliver the pound of butter. Whereas if it's a contract of sale and it turns out that he doesn't perform, you can either sue to get specific performance of the thing, if it's available, or to recover your lost profits if it turns out that it's not. So the Romans have this, and mutum is just one of these little contracts. A much more important class of contract, which is a kind of real contract, are contracts of bailments. And again, you ask the typical question of most individuals, you say, what is a contract of bailment? And they look at you as though you're speaking a foreign language. You ask the further question, have you ever entered into a contract of bailment? And they would say, I've never done anything so immoral as that in my life. But in fact, everybody enters into contracts of bailment many times a day. So let's give the simplest form of bailment. What happens is that it turns out you're going into the bank, and what you need to do is to fill out a form, and you forgot to bring a pen, so you go to the teller and say, teller, can you please lend me a pen, is the term that we would typically use. The teller says, sure. And what happens is you then fill the thing out. Well, now suppose what happens is, having said all of this, you say, thank you for the pen, put it in your pocket, and start to walk out of the store. And somebody will say, well, this is not a gift. This was a loan. And so that there's a sheer obligation to return under these things. And even if they say, can you give me a pen as opposed to lend me a pen, in the context of the store type arrangement, everybody understands what the arrangement turns out to be. And the interesting feature about these social arrangements is that statements about intent and about your state of mind, far from being unavailable, inaccessible, remote, and confused, they're so obvious that what would happen is the jaws would start to drop if it turned out that, having received this pen in this particular context, you treated it as though it were a gift of your own. It's just not what was understood. And the same thing is if you borrow from your neighbor in a classroom a pen in order to fill out a form and so forth. And so we all understand what these bailment arrangements are, and we understand what the fundamental obligation is. So the definition of a bailment is essentially a contract in which property is delivered, that's the real part of the contract, under an obligation to return it after the particular period of use is over. And it's a very powerful kind of relationships which we all understand.
How can simple arrangements help us to understand more complex ones?
Now, is it a simple relationship or not? Well, the answer is the shorter the duration of the bailment, the simpler the thing is. So if it's a question of simply borrowing something for 10 seconds to fill out a form and then giving it back, you're not going to see the bank saying, I lent you the pen, but you took some ink of the pen when you put it on this piece of paper, and now it was basically a transfer to you of the thing. You have to pay me for that. People are going to start looking at you as though you're crazy because of the usual wear and tear and ordinary use kinds of limitations. And so you return the thing and you're done. But now what's going to happen if the uses become more intensive and it turns out that the gap between the time that the property is given and the time that the property is returned starts to increase, and the various purposes for which these things start to change in one way or another? And so what the Romans did in quite an extraordinary feat is they developed a six-fold classification of bailments. I never quite remember them all, but the basic point is that some of them are for the benefit of the owner of the property, some of them are designed for the joint benefit of both sides, some of them are designed for the exclusive benefit of the party who lends the thing. These things are going to have much longer times. And now bailment contracts at this particular point start to become very much more complicated. And so what are the kinds of issues that can start to arise? Well, the first one that I mentioned is for cui bono, for whose benefit is this particular arrangement made? And sometimes what will happen is I will come to you and say, I'm going out of town, and what I would like you to do is, since I have this particular book or statute. I can't leave it in my apartment because I don't trust my roommate. Well, you put it in your house and hold it for me until they come back. And that's called a contract of deposit. And the clear understanding about this arrangement is that you will return it when the person returns and give it. But now something bad starts to happen in the middle or some complications take place. What is to be done? So suppose what you do is normally when you get a statute like this, you put it in a room which has a safe and you lock the door. But in this case, you're a little bit lazy. And what you do is you leave the other guy's side outside of the house. And now somebody turns out to rob the house and to take this thing. And the question you're going to have to ask is whether or not the bailee is responsible for the loss of the thing if he did not, in fact, put it inside the safe. And the rule in this particular case is not a very exacting standard. The Roman intuition, which is every bit as strong today as it was then, if you're doing somebody a favor, they can't ask for you to do something which you may not be able to achieve, which they would be able to do if you were a merchant or commercial party. And so in this particular case, if it turns out that you would put the thing in the safe and it handled it the way you would handle your own property, and some guy comes in and cracks the safe and takes your stuff and his stuff at the same time, nobody's going to allow the bailor to recover. The risk of loss will not have passed under those circumstances. But if, in fact, you didn't put the thing in the safe and it was a trivial attitude, then we say at this particular point, since you don't take the care of somebody else's goods, that you take care of your own, we can argue that this sort of verges on a bad faith type situation because the understanding when you gave this stuff is that you want him to do with your property what he does with his own property. And so at that particular point, the case for liability is going to be much stronger in terms of the way in which these things happen. And so now the first thing you've done is you figured out in a bailment type arrangement, which is gratuitous, what do we do if we're dealing with a situation in which a third party comes in and messes up the overall situation by theft? But of course, property can be destroyed in all sorts of other ways. And so now suppose what happens is what you do is you give the thing to the bailee and a huge storm comes up and it wipes away the house and destroys everything in that house of the owner and your stuff. And the usual rule, if this were a mutum, would be res perit domino. You bought the sugar, you take the risk. But here you haven't bought anything. And so the typical argument is that when it comes to an act of God that's beyond the control of anybody, in virtually every case, the risk falls on the owner of the property rather than on the person who has engaged in this one way or another. So that's the second question. Well, then you get a third question. You can start to see how these things start to expand. What happens is you lend the thing, and the guy decides, I'd like to use it in a party that I have. So you take it out of the safe for the moment, you put it on the counter, and somebody knocks the thing over and it's damaged. And so the question you have to then ask is whether or not this counts as an authorized use of the question. And of course, you don't have any particular things to tell you about an explicit arrangement. This particular party only became a possibility after the bailment had been made rather than before. And so the general rule with respect to a bailment is that you're not supposed to use a thing for your own private benefit. And if you basically deviate from that rule, then it turns out that you're going to be responsible.
What about situations involving third parties?
And so what you do with this first class of deposits is you then start to figure out all of these arrangements, and it just keeps on going. So the next thing you do is you say, well, I can't really deal with this thing because I'm going out of town. So what I'm going to do is give it to my friend as a sub-bailment, and they'll take care of it. But you do it without authorization. Well, who takes the risk if something goes wrong with the sub-bailee is the kind of question you're going to have to ask. And the general rule is it's probably the bailee rather than the bailor. But suppose the bailee, in fact, takes every bit as good care of the thing as the bailor, then it may go back in the other direction. So you're trying to fill in all of these kinds of arrangements, and it gets to be very complicated. And so that's the case in which it turns out you're doing it for the benefit of the other side. But now suppose what you do is when you lend it to somebody, you're doing it for his use. So what you do is you give him all this statute, or you give him the dishes and so forth, and that party is going to start to use it for a party. Or what you do is you give somebody a horse, and that somebody is going to use it. So the question then is, what happens if there's a kind of a risk that takes place in the ordinary use of this thing? Does the risk fall on the bailor or upon the bailee? And you can start to see it's just not quite as clear as you might wish as to which way it would go. And so the easy cases are not too hard to identify. What you do is you say, yes, you're going to use it for a dinner party. And then what you do is you have a rather raucous dinner party in which you take all the silverware and you start treating it as frisbees up and down the room. And it's quite clear that that clearly goes outside the scope of a bailment. And the famous example in Roman times is, I lend you a horse and I say it's yours to use and to ride. And what you do is you decide now to go helter-skelter at a gallop in a very dangerous course, and the thing turns up lame. And the answer is no, we didn't mean that the scope of the consent went for any old use that you had. It only went to the kinds of uses that are consistent with the long-term safety of the animal. So the risks are going to start to move in this direction and one way or another. So you get the second class of bailments. And then suppose what you do is you pawn property to somebody else. Well, in that particular case, he's not supposed to use it at all. You've lost the value of the property. He's lost the value of the property. He's got to return it when you pay the interest and so forth. But if, in fact, it turns out you default on the arrangement, then the property becomes his and he can start to sell it to somebody else. So in earlier times, you have all of these bailments. You have to figure out standards of care, what you do with acts of God, what you do with wrongful acts of third parties, and so forth. And the Romans were quite relentless and meticulous in the division that they had with respect to these kinds of cases. And well, how well does this last? There's a famous English case called Coggs and Bernard, which was decided by Chief Justice Holt around 1703 and so forth. And he's trying to develop the English law of bailments because, people lend things out for dinner parties in the Great Britain as they do in Roman time. And what he does is he basically bodily lifts up the same standards that the Romans had and makes it into English law using the Roman names for all of the particular contracts in question and all the particular variations that we see. So there is, in effect, when you're doing this stuff, just an absolutely tremendous continuity between the law. What then happens in modern times, and I'll sort of finish on this note for the particular area, is what happens is the Romans had this very strong system of classification. They put something into this category, into that category. And what they therefore did is for each category, they would assign a series of rules which dealt with the mishaps that happened under various kinds of an arrangement. Because the only time these bailment issues become an issue is when something actually goes wrong. When you just take the pen and return it, nobody even thinks that there was a contract, but if surely there was.
Why were the categories so important for the Romans?
What the Romans believed is that what you did is you did the hard categories. And essentially what you then did is you dealt with marginal cases and ambiguities on an ad hoc basis to put them into one category or another. And so you would start to do that with respect to bailments, and you could do the same thing with respect to the occupation, for example, of land. You're a trespasser, you're a social guest on the one hand, or you're a business guest, and then we give you legal rules to figure out what the risk of liability are. And they're the exact same principles you'd use in other areas, whereas for mutual benefit, there's a higher standard of care. Where it's gratuitous, the party who is doing the favor gets the benefit of the doubt on these cases, and so on down the line. When you get to modern law, the common law, I think, goes wrong today, because what we do is we do this stuff as a reasonableness standard, but there's a subtle change in the way in which the rules work. The Roman stuff was that categories had to be right, and the difficulties came in dealing with marginal cases. What the modern law tends to do is to say, look, we don't trust these categories. We're going to have sliding scales of reasonableness that go from one end to another, and we're not going to have these hard lines. So what happens is, in this system with the continuity, you don't have to worry about the borderline cases because there are no borders. But the greater failing is this. If, in fact, human conduct is highly irregular, so that the probability of getting yourself into one of these marginal cases is relatively low, the better business judgment is to give you clear rules that cover 98% of the cases and worry about the 2% of the cases later, rather than to jeopardize the 98% of the cases because you're not quite really sure what's going to be required, and leave it to everybody else's imagination. And so this then becomes, in modern terms, the rule v. standards debate. And there may be circumstances where standards are certainly going to be appropriate, but by and large, they're not going to be in everyday relationships. And why is that? Because when people organize their own lives in dealing with small transactions, they're really not particularly congenial with a type of situation in which they don't know where they stand. And so if you're trying to figure out how you give people instructions to resolve disputes outside the framework of a legal system, the category approach and the normal standards are there. The genius is to get the right rules, and the Romans did that because they understood that gratuitous promises were a really important class of cases. There may not be executory enforcement, but there are all sorts of things that take place once the transaction is started, before the thing is completely unwound. And then when we come back to this stuff, what we're going to do to formal contracts and figure out how it is that they deal from the real contracts before we turn, as a final part of this thing, to the consensual contracts. All of this stuff being relatively complicated.
Thank you for listening to this episode of the Number 86 lecture series. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number 86 for lectures and videos on federalism, separation of powers, the judiciary, and more. That's fedsoc.org/NO86. Thanks for listening. See you in class.